Good evening, everyone, and welcome to the launch event for Volume 45, Issue 1 of the University of New South Wales Law Journal. On behalf of the journal, I would like to begin tonight's proceedings by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of the land on which we gather here this evening. We pay our respects to their elders past, present, and emerging, and extend that respect to all Aboriginal and Torres Strait Islander peoples joining us for this occasion. My name is Darius Dadgosta, and I am the Executive Editor of the University of New South Wales Law Journal. It is a privilege to welcome everyone here tonight to the launch event for Volume 45, Issue 1 of the University of New South Wales Law Journal at Allens' Sydney office, the journal's first in-person launch event held at the premises of a premier sponsor since 2019. The UNSW Law Journal is very proud of its long-standing relationship with premier sponsor Allens, which since 1981 has been integral to the journal's development and present status as one of Australia's leading academic law reviews. The journal would not be the esteemed publication that it is today without the over 41 years of continuing support from Allens. I would like to thank in particular Ms. Lisa Miller and Ms. Kajol Mupanar for their assistance in helping organise tonight's launch event, and Mr. Tim Stewart, partner at Allens, who will be speaking on behalf of the firm shortly. I would also like to thank the journal's other long-standing premier sponsors, Herbert Smith Freehills and King & Wood Mallisons, and the journal's newest premier sponsor, Cause Chambers Westgarth, for their invaluable support. Issue 45.1 of the UNSW Law Journal features 6 general articles which explore an array of independent topics and 7 thematic articles, which examine a breadth of topics relating to abuse of power. I would like to thank all of the authors, some of whom are here this evening, for entrusting the UNSW Law Journal with their insightful scholarly works for this issue, and would also like to thank Ms. Yasmin Poole, a leading youth advocate who has travelled all the way from Melbourne to deliver tonight's highly anticipated keynote address on abuse of power. Congratulations are also in order for Kari Mayman, the editor of issue 45.1, for formulating such a timely thematic topic and working so tirelessly in coordinating the peer review and editing of the articles in this issue. It is no easy feat to see an entire issue through to publication, and the editorial board is very proud of the way in which Kari did so with such positivity and dedication. I would also like to take this opportunity to thank the rest of the editorial board for their many hours of meticulous editing, and welcome to the journal's executive committee, Kari's successor, Enrico Mainis, who I am confident will also be a great issue editor. Last but not least, I would like to thank the UNSW Faculty of Law and Justice, particularly the faculty's dean, Professor Andrew Lynch, who will be delivering a vote of thanks later this evening, and faculty advisors Professors Gary Edmond and Rosalind Dixon for their unwavering support of the journal and editorial board. It is now my pleasure to invite Mr. Tim Stewart, a partner at Allens with extensive experience in banking and finance, to speak on behalf of Allens. Thank you.
Thanks very much, Darius. And before I begin, I would also like to acknowledge the traditional owners of the land on which we meet today, the Gadigal people of the Eora Nation, and I do pay my respects to their elders past, present and emerging as well. It's really great to see you all here in real life. It's been sort of a long time coming. It sort of feels like it's been too long. I do recall introducing the journal for the last couple of years via video, but there's something quite special about seeing everyone in our offices, and we're really excited to be able to host this launch and host all these people. And for your benefit, you're the biggest group of people that we've had at the firm since we've been reopening this year. So thank you very much for everyone making the effort to come. As you may or may not be aware, Allens is in its 200th year. We were established in 1822, and history is something that is really important to us. If you get an opportunity when you came in, there's a sort of a summary of sort of some of our history in the foyer, and we do encourage you to look at it. But again, Allens is really pleased to be supporting the UNSW Law Journal. As Darius mentioned, this is our 41st year of sponsorship, having commenced our support in 1981. As I've said previously at launch events, I'm a very proud ex-student of UNSW and very proud of the journal and the work that the journal does in exploring issues that have real resonance for our times, and issue number 45.1 is no exception. Power has long been a curiosity for scholars and commentators, and some of society's most commonly tossed around quotes revolve around power. Power corrupts, absolute power corrupts absolutely. To test a person's character is to give a person power, etc. With apologies for misquoting the original authors on all of those quotes. But power is ubiquitous. It's in everything, every interaction. And probably more relevantly to this discussion, a power differential, or even a perceived power differential, pervades all facets of life. Sometimes this is harmless, but absolutely there are circumstances where a power imbalance is used to the gain of some and to the detriment of others. And it's this abuse of power, which Darius has referred to, that provides a thematic to the issue 45.1 of the UNSW Law Journal. I would like to again take the opportunity to thank you all for coming. Thank you very much for giving us the opportunity to launch this journal. I would also like to welcome Yasmin Poole to joining us today. Thank you very much for coming up from Melbourne. I'm also very interested to hear what you have to say. But I would also like to add my congratulations and welcome to the entire UNSW Law Journal editorial board, and in particular, Carrie Mayman, the editor of issue 45.1. And with that, I would like to invite Carrie to the lectern to introduce the issue. Thank you.
Thank you, Tim, and good evening, everyone. My name is Carrie Mayman, and I am honoured to introduce issue 45.1 of the UNSW Law Journal as its issue editor. I would also like to begin by acknowledging the Gadigal people of the Eora Nation on whose land we gather tonight, and pay my respects to elders past, present, and emerging. I extend that respects to all First Nations people with us tonight and acknowledge that this land was stolen and never ceded. I would also like to welcome our keynote speaker, Yasmin Poole. We are so privileged to have someone with so much demonstrated commitment to change and who is a role model to so many in this room speak on the thematic abuse of power. I also extend a warm welcome to Andrew Lynch, Dean of the UNSW Faculty of Law and Justice, Mr. Tim Stewart of Allens, my family who drove 5 hours to be with us today, and everyone who has joined me in celebrating the launch of issue 45.1. Ever since I was a child, I have been a lover of words. Whether I'm reading them or writing them, to me, words always have meaning. Words, as Malala Yousafzai once said, can change the world. This belief informed the creation of the thematic for this issue, abuse of power. Historically, there has been a noticeable lack of conversation in the mainstream Australian media about those in positions of privilege exploiting their power. Issues primarily impacting minority and vulnerable groups, such as domestic and sexual violence, discrimination on the basis of race, sex, and sexuality, and worker exploitation were labelled women's issues, private matters, or, most damagingly, not my business. However, in 2020 and 2021, due to a likely combination of the pandemic and the tireless work of activists, brave words exposed our legal system as having failed our most vulnerable in many respects. Like many people in this room, I was inspired by the courage of Brittany Higgins, Grace Tame, and Chanel Contos. Like many, I was deeply saddened and angered by the unacceptable numbers of Aboriginal and Torres Strait Islander people dying in custody as exposed by the Black Lives Matter movement in Australia and preceding Royal Commission. And like many, I was deeply concerned by allegations of rorting levelled at state and federal governments in our country. As any good law student does, I looked to the legal literature in an attempt to understand these issues and the many more that were circulating through our newscape in early 2021. But where I expected noise, I was met with silence. It is a primary function of the law to hold those in power to account and to ensure that their power is not misused. This issue addresses the dearth of words on this important topic in the academic space and questions whether the law in Australia is adequately fulfilling this imperative function. At the beginning of my tenure as issue editor, the articles within these pages, the words that would fill the dearth, was my absolute focus. I am incredibly proud to say that the authors of the 7 thematic articles took this theme beyond anything that I could have imagined. I am grateful to these authors for believing in the importance of the theme. I also extend a warm thank you to the authors of the 6 wonderful general articles in this issue, some of whom join us tonight. It is no small act to trust another with your ideas, and I am privileged in playing a part in publishing yours. I hope that these articles spark conversation, debate, and, most importantly, change where it is needed. But words alone aren't enough to spark change. They simply light the match. I am heartened by the way that younger generations have begun to speak out against abuses of power, by people like Yasmin, people like Grace and Brittany, and people like you, the editorial board, and the youth of our society. You are the future judges, politicians, and policymakers. If I had to bet on anyone to make some noise, I would be betting on all of you. When I began my time as issue editor, I thought that my experience would be defined by the heavy weight of this thematic. And in a way, this has proven true. However, the further I got in my tenure, the more I realised that issue 45.1 and the UNSW Law Journal as a whole is more than the words on these pages. Despite my passion for this theme and for the articles within this issue, it is not just this that made my time as issue editor one of the most transformative, worthwhile experiences of my life. It is all those who stand behind it and have stood with me over the past 12 months. In other words, it is all of you. Words are important to me. Words mean something. But for once in my life, I'm at a loss as to how to convey how incredibly grateful I am for the journal and for all of you. But I'm going to try, and I'm going to try not to cry while I do it. Firstly, to our wonderful boardies. I cannot thank you enough for your hard work, patience, good humour, and uncanny ability to detect italicised commas. But more than this, I thank you for your friendship. I love watching Matilda's games with Chan, teasing Leighton in RCD with Alicia, having coffee with the beautiful Sian, and waving at Brad every Tuesday and Friday from across the law building. Getting to know you all has been the highlight of my time on the executive committee, and I'm so proud of the culture of our little group of pedants. The journal is also the faculty that stands behind it. I thank the University of New South Wales Faculty of Law and Justice and Dean Andrew Lynch, whose steadfast support and pride in our work is deeply appreciated. There is no faculty I would rather call home. I sincerely thank Associate Professor Janina Bowie for her advice and encouragement when drafting this thematic proposal. Of course, thanks must go to our faculty advisors, Professor Gary Edmond and Rosalind Dixon, for their unending wisdom and willingness to reply to panicked emails at all hours of the day. And let me tell you, when Ros Dixon says you can call her between the hours of 6 a.m. and 10 p.m, she's not joking. I wish to thank Allens for hosting our first in-person firm launch since 2019, and Kajol Mupanar and Lisa Miller for their tireless work in making it happen. I am grateful to our other premier sponsors, Herbert Smith Freehills and King & Wood Mallisons, for their constant support, and extend a warm welcome to Cause Chambers Westcarth as our newest premier sponsor. Thanks must also go to Kerry, our typesetter, and John, our cover designer, whose work is greatly appreciated. Now, I've saved the emotional parts until the end. When I was elected editor of issue 45.1 in March 2021, for the first time in its 45-year history, the Executive Committee of the UNSW Law Journal consisted of all female identifying students. We represented diverse cultures, sexualities, and backgrounds, and together, we were a force to be reckoned with. This group is the perfect example of what happens when you have diversity in leadership. You get shit done. joined by the fabulous executive of Volume 45, the Executive Committee of 2021 and 2022 have utilised our intersectionality to go beyond the pages we publish. We have prioritised diversity, well-being, and editorial board culture in everything we do. I am incredibly proud of the reforms we implemented to further these objectives and the warm, supportive culture we created. But more than this, I'm honoured and privileged to call each of you a dear friend. Whether it be Tina's virtual yoga sessions during lockdown, laughing over name misspellings in emails. Unfortunately, my alter egos Carrie, Kerry, Curry, and Curry could not be here tonight. They may be with a creaky and RNO somewhere else. Unhinged British accents in meetings at my dining room table, Acridi's amazing memes, I would check them out, or Alicia's constant singing, particularly when she is stressed. When I think back on the last 12 months, you are all in so many of the good parts. I often say that Journal has given me more than it gives most people, and I owe this to you. Our wonderful 2022 Executive Editor Darius, your caring, calm nature and thoughtfulness have kept me steady in the whirlwind of the last few months. I can't wait to see where you take the Journal next. Our wonderful forum editors Arnie and Izzy and digital editor Callum, you are also incredibly kind and your behind-the-scenes work is so appreciated. I'm so very grateful to my fellow issue editors Rebecca, Lillian, Acridi and Kat. If Acridi tells me one more time that she's going to miss me, I might cry because I'm going to miss her too. No one understands the process like you guys, and no one makes me laugh like you. You're incredible. But there are 4 special people from the Executive Committee that I'm yet to thank. Don't worry, I haven't forgotten you. Tina, Executive Editor 2021, Alicia, Editor 44.4, Caitlin, Digital Editor 2021, and Georgia, Editor 45.4, who was devastatingly struck with COVID and joins us in spirit from her sickbed. If someone had told me in March last year that being on exec would introduce me to 4 of the most special people in my life, I wouldn't have believed them. Thank you for always being there to celebrate the wins and to work through the tough moments. I extend an extra thanks to Alicia, who's been with me on this journey from day one. There's no one else I'd want by my side. However, as any issue editor knows, there is a very important group of people who are not officially part of the Journal, yet deserve recognition for their invaluable contribution. To my friends and family, my army of supporters, thank you for your interest in my work, your encouragement, and for forcing me to take breaks during lockdown. The fact that so many of you were able to come tonight fills me with so much gratitude. I particularly would like to thank my second family, Karina, Evie, Kyra, Phoebe, Cameron, and Marnie, for their love and support. I know you're very ready for this to be over, and you're going to be seeing a lot more of me now. Okay, finally, to my guests of honour, my parents, Colin and Tracy, my little brother, Liam, and my grandparents, Neville and Yvonne. In academia, it is often said that our work stands on the shoulders of giants, of the people that have paved the way before us. But the people who paved my way, my giants, are you. Don't cry, Mum. You can make me cry. I'm so proud to be the first person in our family to attend university, so proud to be from regional New South Wales, and so proud of the resilience, drive, and ultimately kindness that you instilled in me. Every one of my achievements is made possible by your love and support.
You're welcome.
Way to break the tension. And so ends my love letter to issue 45.1 of the UNSW Law Journal. What started out as an idea became a theme and became so much more than the words in the books that you're holding. I look to the future of the journal with great optimism. To future issue editors, whoever you may be, I say this: relish every challenge and enjoy every triumph. Get to know your fellow executive committee members because they will be your friends for life. Appreciate everything, every interaction, appreciate it all, because it's always more than the words on the page. And with that, I would like to invite someone who perfectly encapsulates everything Issue 45.1 and the 2021 and 22 Executive Committee stands for. Yasmin Poole is a youth advocate, public speaker and board director. She is the National Ambassador of Plan International and non-executive board director of Oz Harvest and the YWCA. She was the 2021 Martin Luther King Jr. Centre Youth Influencer of the Year, the youngest ever person to be commended to the Victorian Honour Roll of Women, and later this year will travel to Oxford on a Rhodes Scholarship to complete her Master of Women's and Gender Studies. We are so honoured to have Yasmin here with us tonight. Please join me in warmly welcoming Yasmin Poole to officially launch Issue 45.1 of the UNSW Law Journal.
Goodness, that speech almost made me cry. I was trying to gear up for my speech. Good evening, everyone. Well, I know that many people in this audience today are law students. I actually graduated in February, so I feel your pain. And special shout out to equity students because I really feel your pain there. So I'd first like to also acknowledge the Gadigal people of the Eora Nation and pay my deepest respects to elders, both past, present and emerging. I also want to preface by saying this talk will contain mentions of sexual assault later in the speech. I visited Parliament House when I was 12 years old. My classmates and I sat on a bus from my school in Queensland to Canberra. Needless to say, we were tired and sore and miserable. When we finally arrived and started our tour of Parliament House, most people's eyes glazed over. I suppose they were reserving their very last shred of energy for Questacon, and I don't blame them. But I've never forgotten that visit to Parliament House. The tour guide brought us to the House of Representatives. It was a sea of wall-to-wall green. Every footstep, every noise echoed. The chamber was empty that day. I peered down and looked at the seats below me. At 12 years old, I felt the weight of change. I realised that every single person who had sat in those seats had an opportunity to change what this country could be. It tugged at my heart. I thought to myself, this is the place where we can really do something. A decade later, in 2021, my life had changed in many ways. I was 22 years old and embarking on my final year of law at the Australian National University. I was a youth advocate and deeply passionate about empowering more young women to enter politics and leadership spaces. But something happened last year that made me stop in my tracks. I was studying in my dorm room one warm February day when I received a text from my mother. It was a link to a news.com.au article. The title read, "Young staffer Brittany Higgins says she was raped at Parliament House." I read it and felt sick. Brittany was 24 years old, only slightly older than me. Over the next few weeks, my horror grew. It was revealed that some of our most powerful politicians were aware of the incident and turned away when they were needed the most. The Prime Minister's office was exposed for backgrounding Brittany and her partner when she went public with her story. It was a crucial moment for our leaders to display accountability and humility. That didn't happen. It became a political problem to duck and weave through talking points. Blame was the name of the game. And it wasn't just the right. Some parties on the left opportunistically responded by showing their female politicians holding babies to demonstrate how they were the party for women. This misses the point that the conversation was about sexual violence, not motherhood. Like many, I attended the March for Justice protest in Canberra to express a collective anger about the treatment of survivors in this country, the majority being women. I stood in front of Parliament like I'd once done at 12 years old. I no longer thought, this is the place where we can do something. I thought, why didn't you do something? I realised that it's not enough to tell young women to put their hand up for politics or leadership like I had previously done. we also need to call out the system for what it is. 1 in 3 political staffers have experienced sexual harassment or assault. That's not a few bad apples. That's not a once-off. Politics is, right now, a culture of abuse, a pressure cooker of power, fear, ambition, elitism, and hierarchy. This view is shared by many young women across Australia. According to Plan International Australia's Represent Us report, 3/4 of young women aged 18 to 24 disagree with the notion that politics is an equal space for all. 89% of young women think it's easier for men to succeed in political careers. And 59% believe that Parliament has not become a safer and more equal workplace for young women in the last year. Let that number be a reflection on where we are in terms of our democracy. Young women aren't just reluctant to enter into politics. They are unsure if they will even be kept physically safe. The topic of Volume 45.1 of the UNSW Law Journal is abuse of power. Now, I've talked about abuse in the form of sexual harassment and assault, but I want to separate that word power for a moment, to examine what power means and how it operates in our society. So on the topic of power, let's consider an example that we're all familiar with, the internet. Most of our time is spent on social media apps like Facebook, Instagram, Twitter. To some extent, we have agency over what we see, what we click on, when we log off. But we don't have design power. As users, our agency is constrained to the rules and boundaries of these applications. We can't change these rules, and we can't change the algorithm. And that doesn't mean those rules are fair, equitable, or just. Who has power? Those who can design the rules are tech billionaires, largely from the same gender, race, class, and from the same country, with enormously powerful companies behind them. These rules are designed to be exploited by those who are most powerful. One example is free basics. In 2016, Facebook, now Meta, committed to connect the unconnected by creating a service that provided free access to the internet, which was rolled out in 32 African countries. But it was a walled internet. Users only had access to Facebook and its subsidiary social media companies like Instagram. Under this altruism was a clear intention to dominate the local market, leveraging its financial and infrastructural power to get in first and sidesweep any local competitors. The ability to change these rules is not in the hands of the average user. In fact, it's a fundamentally undemocratic process, as seen by Elon Musk, a self-described free speech absolutist who has used his financial power to buy the largest shareholding of Twitter. He was then invited onto Twitter's board and subsequently attempted a hostile takeover of the company. The group that holds the power is the group that holds the toolbox. It's the group that can set the boundaries of what we as users can do. In this instance, boundaries that we often accept uncritically. It's a small elite that can make design choices about our communication, our ideologies, and our freedom of speech. So are free basics and Elon Musk's Twitter antics abuses of power? I would say so. But I also see it as a deeper problem. Those who create the rules of the game are inclined to create rules that will continuously benefit them. The abuse of power is not just about an individual decision maker, but a system that enables abuse to occur. This analogy is useful to understand power and parliament, where the nature of the political system and boundaries of political debate is accepted without considering who designed them to begin with. Let's start with the Constitution, the foundation of our system. the drafting of the Constitution was not a democratic process. There was not a single woman that was involved in the drafting of the Constitution or were eligible to elect delegates. And I wonder, what would our society and power structures look like if women were in the room then? As an aside, it's really interesting that the heart of the Constitution is an implied doctrine of representative government when it was created through a process that was not representative at all. We also see that power was used to harm others since Parliament's very beginning. The White Australia policy was introduced in 1901 and was one of the first Commonwealth laws passed after Federation. The law banned non-white migrants from entering the country, driven by fears of an Asian invasion following the Chinese presence during the gold rush. Some groups had no access to politics whatsoever. White women were given the right to vote in 1902, but First Nations women were only permitted to vote in 1962. The White Australia policy was abolished in 1973, 7 decades after the fact, giving women of colour a greater say in the history of this country. These foundations are not separate from the current day, where men have and continue to dominate power. It's not separate from the sexist treatment of female politicians like Julia Gillard or Julia Banks. It is not separate from the chorus of men who came out swinging against Grace Tame's decision not to smile next to the Prime Minister. Sexism, racism, and other forms of discrimination have been legitimised in politics right from the very beginning. These rules have served wealthy white men for generations, meaning they have the power to gatekeep women and diverse communities from accessing power and get away with it. One walk around Parliament House and looking at the portraits on the wall confirms that fact. So I argue, abuse of power isn't just about one decision maker using their power for personal gain. These examples, the drafting of the Constitution, the White Australia policy, and the exclusion of diverse women in politics are abusive systems. Such systems are drafted, enacted, and constructed with the intent to protect the interests of the designers, wealthy white men, at the expense of the oppressed. These are the boundaries that we operate in. A discussion about abuse of power cannot only consider the abuse from an individual. It must consider the abuses of systems. So let me illustrate this point about abusive systems a little bit further. To this day, power structures in Australia produce and sustain racism, classism, sexism, and other forms of discrimination. The legal system often avoids acknowledging that systems can privilege some while oppressing others, and its silence can be damaging. One case that illustrates systemic oppression and the law's silence is Roach and Electoral Commissioner. I analysed this case in my thesis that I did last year, called An Intersectional Analysis of the Implied Freedom of Political Communication, which one day I hope to publish in the future. In Roach, the High Court considered whether legislation banning all prisoners from voting was constitutional. The bench struck this legislation down. However, it didn't strike down the original law, which prevented prisoners from voting if their jail term was 3 years or longer. So let's consider that for a moment. What's the consequence of depriving some prisoners from the right to vote? And how does this deepen power imbalances? Well, let's look at the plaintiff in that case, Vicki Roach. She was a First Nations female prisoner that was serving a sentence of 6 years, which meant that even after the case concluded, she still couldn't vote. She'd spent her life inside and outside of the prison system since the age of 12. Across her life, she experienced many barriers, including being raised in foster care, limited education, and was a survivor of domestic violence. Like Vicki, almost 1/3 of female prisoners are First Nations. This is despite First Nations women comprising 3% of women. This disproportionate number is due to systemic barriers similar to what Vicki experienced alongside institutional racism, such as over-policing. Preventing this group of prisoners would not have an equal effect on society. It means that the disadvantaged become even more disadvantaged, affecting communities with limited platforms and resources who now have even less of a say in our democratic process. And we saw during Black Lives Matter and that conversation about Indigenous deaths in custody just how important hearing from those communities are. The court could have considered these problems and still reached the same outcome. My issue is that they did not. There was not one mention of race and class. They referred to prisoners as one homogenous group. The court's fear of appearing political or biased meant that it refused to see the problem in real terms and acknowledge power imbalances. Its silence means that those who are disadvantaged are not seen or considered in the decision-making process. Now, this case isn't about abuse of power in an individual decision-maker sense, yet it clearly shows how power can be used to entrench disadvantage. Another relevant case is Comcare in Banerjee. This case involved a public servant who had an anonymous Twitter account that was critical of the government. She was fired under the APS Code of Conduct. The court found that this was constitutional because the public service must be impartial, neutral, and apolitical to function effectively. Now, let's pull out those words for a moment. Impartial, neutral, apolitical. Once again, the court referred to public servants as one homogenous group. They are not. In fact, they're highly diverse, including staff who are First Nations, culturally diverse, and queer. It's easy enough to remain neutral and silent if you are already benefited by the status quo. But requiring silence inside and outside of work is harder for groups who are disadvantaged by the systems around us. Putting it simply, asking a white public servant to remain neutral compared to a First Nations public servant is not the same ask, and this silence inflicts pain. The practical reality is that diverse people would be less inclined to join the public service, meaning that public policy is not reflective of the society around us. This case doesn't concern a direct abuse of power on an individual decision-maker level. However, the court's refusal to acknowledge group differences and systemic racism, sexism, and classism creates a system that can be abused through privileging some voices while silencing others. The court's use of universal and neutral language renders itself blind to these differences. This blindness favours the same people that created our systems of power to begin with, wealthy white men, who are seen and represented in this universal language, whereas minority groups are not. Now, I want to turn back to volume 45.1 of the UNSW Law Journal. This edition contains diverse and thought-provoking articles about abuse of power. Some articles examine the law's role in facilitating abuse. Berg, Dam and Vogel argue that Australia's temporary visa regime is an abuse of government power and leaves refugees and asylum seekers open to workplace exploitation. Rawling and Riley Munton also consider the gig economy, where the lack of regulation enables Uber, Deliveroo and Menulog to exploit their workers due to lack of regulation. In happier news, the law is not always the abuser and can instead be a powerful tool to curb abuse. Kotzman, Begaric, Wolf and Stonebridge recommend the introduction of new laws that recognise animals as sentient victims of domestic violence. Simmons, Byrne and McLeod propose a national compensation scheme to support and protect victims of modern slavery. So I hope that everything that I covered today provides some food for thought, and I'm confident that the articles in edition 45.1 will add some fascinating colours to this topic. I'll end on a quote by John Adams, former US president, who once said the following: "Power always sincerely, conscientiously believes itself right. Power always thinks it has a great soul and vast views beyond the comprehension of the weak." As we look out for abuse of power, let us never accept power uncritically and always examine where it comes from, who it empowers, and who it harms. After all, it's no use pruning the leaves when the roots are rotting beneath the surface. Thank you.
Good evening. My name's Andrew Lynch and I'm the Dean of the Faculty of Law and Justice, and I would also like to begin my very brief remarks by acknowledging the traditional owners of the land on which we're gathered, the Gadigal people of the Eora Nation, and I pay my respects to their elders past and present and extend a particular acknowledgement to any Aboriginal or Torres Strait Islanders in the audience tonight. And I was thinking, as Yasmin was speaking, about the way in which we begin our remarks by an acknowledgement of traditional owners. And obviously I was also put in mind of the Constitution's many deficiencies and omissions, and Yasmin's very succinct and apt criticism of the process by which it came about and the power structure that it represents, and continues to do so, well over 120 years on from drafting. And that put me in mind, of course, of something a bit more hopeful, but also the difficulty of challenging those structures, and that's the work around the Uluru Statement from the Heart, which is coming up to its 5th anniversary this year. And I'm very proud of the connection that UNSW has to that work, chiefly through the Pro-Vice-Chancellor Indigenous, Professor Megan Davis, who's a professor in this faculty. But the difficulty of that campaign and how far it has come, but how far it still has to go, is a great demonstration, really, of the struggle to be included, to change the status quo, to resist structures which were put in place at the end of the 19th century. And so I think Yasmin's remarks on that, and actually I didn't expect it to be so constitutional in flavour, and as a constitutional lawyer who now spends so much time deaning, it was such a pleasure to listen to you talking about these cases and also the drafting of the Constitution. But in hearing all of that, I was put in mind that there's a responsibility on all of us, particularly those of us who have been exposed to these issues, who know how the court system works and the exclusion that's embedded in our Constitution, to explain amongst our friends and family and the rest of the community what Uluru represents. It was a gift to the Australian people, not to the politicians, very wisely. If you've heard Megan and others speak on it, the presentation of the statement wasn't made to political leaders. It doesn't sit behind a glass frame in Parliament House like earlier instruments given by Indigenous Australians to the political class. It travels around in a very long plastic tube and is displayed to people. It's a beautiful work of art in and of itself, and it's an opportunity for all of Australia to come together and to redress the exclusion of First Australians from our constitutional system. That was one reaction I had to Yasmin's wonderful speech, and I'm sure all of you had a range of different other ones as well, and I look forward to us talking about those over drinks afterwards. But that was the first thing that was put in mind, is that there is something happening right now that we can use to redress some of the problems that you've mentioned. But those problems are vast, and they extend well beyond the Constitution and go to lots of different other institutions. And I was also thinking, in terms of powerful institutions, of the universities. Universities are powerful institutions and they have responsibilities to their students and also to their staff. And the national survey results that came out very recently highlight the many challenges for the university sector in providing a safe place for students to study, free from assault, abuse, discrimination and harassment. And I assure all of you, but particularly the students of UNSW, how earnestly those results are discussed at the university level and also at the faculty level. We had a faculty conversation just this week around, what's the special responsibility for the Faculty of Law and Justice, given that those issues directly connect to responsibilities and rights and the education that we provide our students. So I think, there's once you start to talk about abuse of power, you recognise how endemic power is throughout society. It's through the places that we work, places that we study, the places that we worship, and it's important to turn that gaze upon oneself as much as it is upon others. So Yasmin, thank you for your address tonight in launching this issue. It was really wonderful to hear from you. The rest of my job, I have the best job of all the speakers tonight. I know that might not come across immediately, obviously, but I get to thank and congratulate everybody for all that they do to make this so successful. And it's a great pleasure to thank Tim Stewart and the team at Allens for their steadfast support of the UNSW Law Journal going over so many years. Tim, it's wonderful to be back at Allens. I think when it was said earlier tonight, this is the first launch of an issue at one of the premier sponsors since 2019, which seems quite amazing to me. And I think it's probably only the second in-person launch that we've had in all of that time as well. We enjoyed one on UNSW campus at the end of last year. But it's really great to be able to connect with our sponsors. The support of the journal is so important. And Allens is a great friend to the Faculty of Law and Justice in so many other ways, very notably through the support of the Allens Hub for Technology, Law and Innovation, headed by my colleague, Professor Lyria Bennett-Moses, and doing wonderful things in terms of AI, digital technology and rights, connecting the piece of technology and our own humanity. I would also thank my colleagues Ros Dixon and Gary Edmond. Ros doesn't take my calls after 6 p.m. So the journal's team are especially favoured. I wouldn't dare. But their work of Gary and Ros is fantastic. Their support for the journal is very deep. They've been doing those roles for a long time now, and I know they're very passionately committed to the journal. Now with congratulations. Carrie, congratulations on the production of your issue, and it is a team effort, I know, but the editor, it's a special thing that you'll have for the rest of your life. It will sit on your shelves and the shelves of your family, I'm sure, who will remember all of the work that went into it, and congratulations on it. I thought you spoke so eloquently about what motivated you towards this theme, and then also so beautifully about all the relationships, friendships, and memories it's created for you. And I thought that was wonderful. So congratulations on steering this ship to its safe harbour and berth of publication. It's a wonderful moment. But of course, congratulations to every single person who has worked on the issue. You only need to look at it to see how many people work on the UNSW Law Journal to make it such an esteemed publication around the world, which it really is. And as has been pointed out, but let me reiterate, the faculty is enormously proud of the UNSW Law Journal, its long history, its unwavering quality, and the dedication of all the students who work on it. So I extend my congratulations to Darius and the executive and everyone who's contributed. And I thank all of you for coming tonight. I think, if anyone was wondering whether there's a difference between a Zoom launch, I would remember sitting in my kitchen recording comments for the Zoom launches, or coming in person. The IRL experience, as they say, can't be beaten. So thank you. It was wonderful to see you all. Good night.
So thank you, Professor Lynch, for that vote of thanks, and thank you, Yasmin, for your thought-provoking keynote address. With Volume 45, Issue 1 of the UNSW Law Journal officially launched, it is now time to conclude tonight's official proceedings. Please feel free to remain and mingle for the next hour or so, and please do not forget to take a complimentary copy of Issue 45-1 if you haven't already. All of the articles in this issue can now also be found on the UNSW Law Journal's website. Thank you all for your attendance, and I hope that you enjoy the rest of your evening.